to now get on the share screen app here and let's see, make sure that I'm doing this correctly. And it looks kind of like I got it here. Okay, 1 second, we'll get that correct. And while I'm doing that, I will mention that unfortunately, I'm not sure we're going to have time for questions. We'll try and see what we can do. But the topics that we're covering is a lot of material that really we're trying to do what I would call for you issue spotting here. And so it's going to be a sky high overview. It's not going to be real detailed here like we might try to do. And most of these issues we could cover in an hour or so, just each by itself. So we do have a lot to cover. If we do have some time for questions, that'll be great. But comment about the title even. California laws are so crazy. It's not a matter of, well, I was trying to be fair. I did everything I thought was right. I did things the employee agreed to. California law is just nuts, let's be honest. And if you're going by common sense to decide what you're going to do with things, you're probably breaking the law, which sounds crazy, but that's unfortunately California. It's pretty nuts. So let's see. One of the things that you need to understand about how we're presenting this is it's going to be very, very brief. As I mentioned, it's not comprehensive. It's not really directed toward folks who really already have a lot of HR experience. The materials are going to give you some idea of things, but really it's about teaching you to spot the issues. Any one of these things, you really should make sure you get some advice. I'm not saying it has to be from me or even from an employment law attorney. It could be a payroll specialist. It could be your CPA. If it is an attorney, I urge you to make sure you get it from somebody who understands California employment law, not just general practice, because this is kind of high level stuff, unfortunately. So let's talk about where we really want to focus. It's on problem prevention, and problem prevention really is going to save you lots of time, lots of money, lots of risk. So we want to focus on all of this. Everything we cover here is really about that. And with HR issues, it's not just that you're going to spend less time and money and energy, preventing problems than if you had to actually go resolve them. It also, with HR, problems can breed all sorts of other problems in your workplace, resentment among employees, damaged relationships, even with customers, their productivity. All of these things are damaging. And then, of course, the worst, perhaps the worst, is litigation. California's culture is a litigation culture. Even if you think somebody's your friend, they would never sue you. Unfortunately, our culture in California is, let's sue everybody. I've got so many clients who are going, I thought this person was like family. I did so many things for them. And when they left, I got slapped with a lawsuit. I had no idea because I always did everything they asked, bent over backwards, did things I didn't even need to do. And yet here I am getting sued. And getting sued is devastating for you personally as well as your business. And yet the people suing you don't seem to get it. They think it's no bigger deal than saying, hey, why don't you pick up the check for lunch today? I've seen folks tell me they had an ex-employee sue them and ran into the grocery store, and the ex-employee comes over and tries to give them a hug going, hey, how are you doing? Did you hear I got a new dog? I mean, they just don't think anything of it. It's so embedded in our culture that you sue people. So we have to be
And Susan,
careful. Yes.
Susan, I'm sorry to interrupt. We are just seeing a white screen right now. We're not seeing any slides
No,
if you're moving through
I
slides.
don't know why I've got the share screen here. So I do apologize on this. I don't understand. We did this earlier in the day and it worked just fine. Let me try the escape here again. Let me go to Zoom. I apologize, folks, especially since we had practiced this to make sure it was going to work. And I don't know what this is. Hang on. It's got something called whiteboard. That may be why.
Oh, yeah. Yeah. So
Okay.
choose your PDF. Yeah. Or your
Okay,
PowerPoint.
there we go. That should do it, folks. I apologize. Let's go
Success.
back to it. Okay, there we go. Is that working now? We're good?
Yes, it is. We can see it. Thanks, Susan.
Great. Okay. Sorry about that, folks. Thought we had this right. I'm not a good host. I apologize. So anyhow, one of the big things that we see in a lot of litigation is hiring the wrong people. We're going to talk a bit about hiring practices, but if you're really careful about whom you hire, who you let in the door in the first place, you're going to go have much better experience with everything from there. And the next really is to maintain a professional business-like relationship with employees. And what that really means is you can still be friendly, have a positive, friendly work environment, but it needs to be collegial, a little bit of an arm's length situation. When you're the owner or manager of a business, everything you do will be viewed through that lens. So if you're inviting people over to your house for dinner, and somebody wants to say there's something creepy about it, unfortunately, it's always going to be, well, that was my boss. Okay. Somebody wants to confide in you, but please don't do anything about it. But so-and-so is harassing me, just telling you as a friend, and so you do nothing about it. Well, guess what? I had that case in trial, and it was the guy was just going, well, she told me to keep it confidential, so I didn't do anything about it. Yeah, but you were her boss, right? Yeah. So you always have to keep in mind that you are the boss, the manager, the business owner, whatever your situation is. And even if you're a coworker, still needs to have some professional aspect in everyone's behavior in the workplace. And again, you can still be accommodating to people. There's nothing wrong with being accommodating. So if somebody says, hey, in this storm we just had, I found out I had a leak in my roof, and I need to take the day off to go get my roof fixed, try to make that work as much as you can. You want to be helpful. But on the other hand, if somebody's saying, wow, I just have all these financial problems and my car broke down, don't just go give them money to replace the car. You can't believe how many times I've seen that happen. Here, I have an old car. Let me just give it to you. It's fine. Or helping arrange for other problems, loaning money, all of these things put you in a situation where, unfortunately, being the nice guy can come back to bite you. So you need to make sure you maintain that professional arm's length relationship. You're employing folks, you're not adopting them. They need to be able to take care of their own issues. Again, you try to accommodate folks where you can, but you're not, you're their boss. So again, constructive criticism means not just dealing with all of the bad things and just telling people where they're messing up. You want to tell them how to improve. It's a great way to do it. You want to stay current on HR laws. If you need to get professional advice on how to deal with those, but there's some great inexpensive ways to find information. Come to seminars like this, or even some you might have to pay a little bit for. I will tell you, I'm not trying to sell my office, but we also do seminars at no cost. If you go to our website, you'll see those. We do them monthly. There are newsletters you can sign up for. The big thing is to make sure that whatever information you're getting, that it's California law. You can look in the paper, you'll see headlines about a new law on something, and it's just the federal law. And if you're complying just with federal law, not only are you failing to comply with California law, but in some cases, you may even be violating California law. So you do not want to just go online and figure out how this works. You need to make sure you stay current with relevant information that's specific to California law. Next really big issue here is you're doing everything right. Let's say you've attended this seminar, a bunch of seminars, you've dug in, you've learned everything there is, and you're doing everything right. The problem is, can you prove it? Unfortunately, if you can't, you may just find yourself as if you did nothing at all. We have a saying in HR law that if it's not in writing, it never happened. And this even goes with people say, well, it was an oral warning. I give people first an oral warning, then a written warning. You can still document your oral warning. You confirm it in a memo the next day or later that day, an email or something saying, hey, I just wanted to confirm that today we talked about XYZ and the expectations are ABC. And I just want to make sure you're really clear on what I expect from you so that you can succeed. Now you've documented it. You haven't, whipped them, turned it into a formal written warning. It's still documented. And this shows that you acted fairly with a lawful purpose, assuming that you did have a lawful purpose. And if you don't do this, or you only do it occasionally, that destroys your credibility. Because now somebody can say you only wrote up people in a certain protected class. Let's say you only wrote up people who were minorities or female or older, and other people were doing things wrong and you never wrote them up. So you do need to be consistent. You need to do this with everybody. Yeah, also just to kind of note, I'm not trying to stoke paranoia, but your employees are probably keeping their own paper trail. So it's going to be you're getting up on the stand and they tell you, look at all these records the employee produced. Can you show me anything to support what you've got or how you handled it? And if you're saying, no, I got nothing, now you're in trouble. So it's very important. Now, at-will employment, a lot of you have heard about at-will employment. And it's something that's very misunderstood. The definition is here, and the big exception swallows the rule, which is basically, yes, you can terminate, you or the employee can end this relationship for any reason or no reason at all, but the employer cannot terminate the relationship if it's going to be for some illegal reason, which makes sense. Somebody's terminated because they went on jury duty. You can kind of see, even if they're so-called at will, I don't need a reason. You just fired them for an illegal reason. Now you have a wrongful termination case. Now, that being said, good cause, here's the definition here for you to look at. But I think the best practical approach to every termination is to act as if good cause is necessary. It first off will make you think about, why are you firing this person? And is anybody else doing the same thing or worse, that you're not dealing with them? But we want to make sure we still protect at will, because if, heaven forbid, you ever are in litigation, that will change the burden of proof and certain things that you're going to have to get into. So we really do want to preserve that at will, but just don't take it for granted that you can then terminate somebody and just go, I'm firing you because I feel like it and I don't need a reason. Not a good way to go. Independent contractors, for those of you who are new to have a new business, you may be thinking, I can't afford employees. I've got to get work comp. I've got to pay payroll taxes. I'm just going to bring people on as independent contractors, or some people say contract employees, which is not a real thing in this respect. Pretty much there's a lot of laws that say everybody's really an employee, and California has gotten to be fairly punitive on this issue in the past few years. And you just have to assume that everybody you're bringing on board is an employee. And think about it. There's two big reasons here. Number one, unions, who have a massive lobby with the California legislature, they want everybody to be an employee. They want to unionize them. They can't unionize independent contractors. And the other is the government wants its payroll taxes, work comp wants its premiums. All of those are reasons why my feeling is why these laws are pushed so hard. But this slide is funky. Here we go. Now we got that slide right. There's a test here that you can look at. The short version of it, just to say, is the ABC test is going to decide whether or not the person's an independent contractor. Controlling the work, well, if you're talking about my roof has a leak and you're calling a roofer, telling them to fix it, you're not controlling the work. You're just saying, I want this result of a roof that no longer leaks. On the other hand, if you have a restaurant and you're telling somebody your job is to bus tables, there's not a whole lot more you need to tell them to control what they're doing. They're bussing the tables. Now, the other one that will get folks is if they're doing, the worker is doing the same work as your entity does, or it's really integrated into the business. So, for example, if you are developing computer, software for apps, and you're bringing in somebody who's going to be a coder or a programmer, and that's the business you're in. So that's going to be an employee right there. And a short version really is that if it quacks like a duck, waddles like a duck, it's probably a duck. If this looks like, hey, this person works for me, they're my, they have a job with me, it's probably because they're your W-2 employee. And let's not kid ourselves. And all the laws are against you going the other direction. So pretty much need to assume that everybody you have on board is a W-2 employee. And with that, let's talk a couple things about hiring. We're going to just kind of look at these quickly. Obviously, you got to advertise the job. As far as using a third party, that could be if it's a high level job for an expensive position, you may want to use a headhunter, or you may just want to use a staffing agency, or you can post things yourself. All of those are fine. There's some benefits to third parties. They can help you screen a lot and help you do things correctly. One thing that's new this year I'm going to mention is the pay transparency law, that you have to include the pay scale and pay information in the ad. So that's important to understand. Quick things, job application forms versus a resume. Even if you're accepting resumes, I urge you to use a job application form. It seeks information that a resume may not provide. It makes it harder for people to hide things from you. There's provisions that you may have them sign that will help protect you and warn them of things that may have them self-select out, like this is going to be an at-will job. There's a lot of information you cannot ask people. And again, before you start hiring, you're going to want to get details about this sort of information. One to keep in mind, criminal background. Believe it or not, you cannot ask somebody about their criminal history in the hiring process until after you make a job offer, which means you're going to want to do that offer on a conditional basis. So here we are offering you the job, but it's contingent on you satisfactorily passing our criminal background check. And even when you do that background check, there's rules about what you can and cannot consider about their criminal record. So you're going to want to know these things. Social media, you cannot go behind the password protected things. There's documentation and record retention requirements. You need to keep things for 3 years after you fill the job or after the person who you hired leaves, whichever's longer. You want to do quality interviews. That could be another couple hour-long seminar, but make sure you know that these are parts of it that you have to get more information about in order to do this properly. Making the offer, always do it in writing. You're going to want that carefully prepared. I suggest you have advice, perhaps from an employment attorney, to help you with a template before you even begin hiring. So you know what elements you're going to need to be discussing with someone you may be offering a job to. But if you don't have it in writing, then again, you may have problems trying to carry out any sort of contingencies, such as a criminal background check. Because if it's not in the written offer letter, you cannot then go back and try to do that as a condition of employment. So very important to make sure this is done properly. Onboarding, very quickly, you're going to need a written checklist about that. And some of this can depend on your industry, number of employees you have, but there are certain things that are all going to be required. For example, a W-2 is legally required, something called an I-9, which is proof that the person can legally work in this country. That's required. California requires you provide people with a notice regarding wages. So there's a number of things that are required. So you're going to want to make sure that you have a checklist. And again, go through that with somebody the first time you're setting it up to make sure it's accurate. And then you're also going to want to update that every year because California loves to change employment laws all the time. So you're going to want to be doing that. Now, once you do hire somebody, remote work has become a big issue. Just going to throw this up here. You should be thinking about these issues when considering whether or not to allow remote work. There's pros and cons. Is it a good idea? If it is, don't forget that you are going to be responsible for either providing equipment like their computer and phone or paying your share of those things if they already have them. There are also security issues in terms of your confidential information that may lead you to prefer providing some of your own equipment to the employee. Those are all things to think about. Now, pay requirements. I want to focus a little time on this. Just know this is complicated stuff. We have federal laws apply as well as state laws. California has many requirements, and in California, a lot of cities and counties have come up with their own rules as well. You're going to have to really know wherever it is that you're situated if there are specific local requirements here. Now, one concept I want everybody to understand is the payroll work day and payroll work week. And that is a defined 7-day period, and you can define it however you want. If you don't define it, the payroll work day is midnight through 11:59 p.m. and Sunday through Saturday. It's not your work schedule. Oh, we only operate Monday through Friday. That's not your payroll work week. You might have somebody come in on a day that, for inventory on a Saturday. The payroll work week is a 7-day period, 168 hours, and you define it. It might be that it's better for you to have a payroll work week that's Monday through Sunday and not Sunday through Saturday. There are issues there that may determine what's best for you. But when you're looking at the pay requirements, and the payroll work week is going to come back into this, you have to assume you're paying everybody hourly. The rules are that the pay laws apply to everybody, and unless the pay laws apply to everybody, unless there's certain exemptions, which are unlikely to apply to a really small employer, you cannot just say, hey, my receptionist is just going to be on a salaried basis, and I'm not going to have to pay overtime. Even if the employee wants to have a fixed pay to count on, no, you're going to pay an hourly rate. So let's just take the example of $20 an hour. If the person works 4 hours and 3 minutes, you pay 4 hours and 3 minutes. You don't just go, well, they work 25 hours a week, I'm just going to pay that no matter what. And you pay for all the time worked, even if it's not authorized. Minimum wage is noted here again, goes up pretty much every January 1st. So always check to make sure you're current, but cities and counties have their own rules, and often those change mid-year. You have to keep track and be sure that you're paying everybody the way you're supposed to. So let's talk about a little of this. Start and stop times have to be accurately recorded. You don't just put on their timesheet, I worked 8 hours, and they just put in 8 and we call it good. If they started at 7:56 a.m., they need to put on their timesheet 7:56 a.m. as their start time. They clocked out for lunch at 11:04. They need to put 11:04 on their timesheet. So this is a very important thing, partly because we also have rest breaks, meal breaks, other things. Anytime that they're going to go off duty, to go run errands, take lunch, go take care of appointments, they clock off. Same thing when they leave for the day. The only exception is rest breaks, which are on the clock. So we'll talk more about these issues later. Okay. Now, regular rate of pay. This is again where California doesn't use common sense. They don't use dictionary definitions. You think regular, oh, I hired somebody to be here at $20 an hour. That's their regular rate of pay. No, that's their base rate of pay for straight time. The regular rate is a term that the state uses when people have other compensation that comes into play. So there might be bonuses or shift differentials or commissions, and all of that comes into play if you're calculating, for example, how much they should get for overtime. So if I have a base rate of $20 an hour and I work overtime, and we'll get into overtime in a moment, but if I'm supposed to get time and a half, sure, if I have no other compensation factored in there, I get $30 for that time and a half overtime hour. On the other hand, though, if I spent all that time not only earning my base of $20 an hour, but I also, that time was spent earning my commissions, my bonus, or shift differential, all of that has to get factored back in and allocated into how much I get for overtime into my regular rate. And we'll have an example of that. And just about everything comes into that calculation. So when you're looking at the regular rate of pay, you're going to pay their base rate, that $20 for all hours that are not overtime, sick pay, or have any other premiums. And then you look at the regular rate for everything else. And that's going to vary from week to week in terms of your payroll work week, whether it's defined as Sunday through Saturday or Monday through Sunday. It's going to maybe vary because how much they earn in commissions or other premiums may vary from week to week. So here's a sample. I want you guys to look at this carefully. Later, you're going to have these materials, and this explains it all. So this is a situation where somebody has bonuses, they have a shift differential. And if you're going to have this situation, I urge you strongly to sit down with your payroll service or whoever it is that's doing your payroll and make sure that you have all of this clear and you carefully check these every week to make sure that you're correct on these, because it can get really tricky. But ordinary overtime, let's just understand what overtime is when you pay it. It's not just extra hours. If somebody is scheduled to work, 4.5 hours today, and they end up working 5, that's not overtime. That's just, hey, they worked a few extra minutes today. Overtime as a legal matter is when somebody works more hours in a day or a week that is allowed under state or federal law. Here in California, it's a state law, and sometimes, again, additional requirements in certain localities. Now, if you can try to schedule people to reduce the instance of overtime, great, but you always pay it when it's worked, even if it wasn't authorized. If somebody works unauthorized overtime, okay, fine, but it's a disciplinary issue if they're doing something they're not supposed to do. And again, look at it carefully. It could be they stayed that extra hour because of a customer who showed up and spent $5,000. Hey, I'm happy they spent that extra time. But if it becomes a problem, you still pay the time and then address any issues. So we need to also note, you may have heard some people go, I get comp time. There's a couple of instances in California where that is legal. They're few and far between, probably do not apply to you. So just again, everybody puts their actual time down on their timesheet and you pay it all. And if you have a problem with it, you address it later as a problem. So when does overtime kick in? There's 5 overtime zones. They're listed here. Some are daily and some are weekly. And you may have heard in California that, for example, you pay overtime whenever someone works more than 8 hours in a day or 40 hours in a week. And we'll give you an example in a minute with a detailed layout of how this works on what that or means, how that works. But first, understand when overtime hits, there's 5 times overtime can occur. 3 of them require you paying time and a half. 2 of them require you paying double time. So you need to know which they are. The anti-pyramiding rule is something I want to point out. We'll be illustrating it in an example in a moment. But that means pretty much you check how many daily overtime hours they work. This is the or part, the over 8 in a day or 40 in a week. So you're going to see how many total daily overtime hours did they work in this payroll work week. Again, only your defined payroll work week. And then how many weekly overtime hours did they work? Now, you don't pay both of those. You don't add them together. What you do is you say, well, which one benefits the employee the most? They had 7 daily overtime hours this week, but 11 weekly overtime hours. We pay the 11. And I'll show you an example here that will illustrate that in just a second. But again, let's see which zones require what. Hours 0 through 8, you pay the straight time. And let's just go again, no bonuses, commissions to complicate this. But let's say somebody's at $20 an hour. So hours 0 through 8 in the day, you pay them their $20. Once they have hit that 8 hours, that first minute after, from 8:01 up through 12, you're paying time and a half. Now, if you skip down, you'll see anything in excess of 12 in that workday, you're going to pay double time. Now, you also pay time and a half if they work more than 40 hours in a single week. We'll get to the or part of this later. And then we have the 7-day rule, which I want people to understand, which is if, again, your same defined payroll work week. If your employee works all 7 days in that payroll work week, then the first 8 hours of that 7th day is paid at time and a half. Now, let's just be clear. This is not any 7 days in a row. If your payroll work week is Sunday through Saturday, Saturday is going to be your 7th day. But this rule only kicks in if they worked all 7. If they skipped work on Monday, you're not triggering this 7-day rule. And it's not just any 7 days in a row. If they worked Monday through Saturday this week, and then worked Sunday, that following payroll work week, they've now worked 7 days in a row, but not in the same payroll work week. That's the following payroll work week. It doesn't matter for what we're looking at in this one. So again, the same single payroll work week, if they work all 7 days, on the 7th day, the first 8 hours on that day are time and a half. Anything over 8 on that would be at double time. So let's look at an example of how you work this out. And again, take your time to study this, but you'll notice on here, Sunday, they worked 0 hours. We are not triggering the 7-day rule here. Again, we have a Sunday through Saturday payroll work week. We're not triggering the 7-day rule, even though they worked every other day that week, including Saturday. Now, how much daily versus weekly? We have 7 daily overtime hours here because on Thursday, they worked 6 hours in excess of 8, and Friday, they worked 1 hour in excess of 8. So before we get into how much they get paid for each of these hours, how many overtime hours were there? Daily, we had 6 hours daily here, 1 hour daily here, for a total for this payroll work week of 7 daily hours. But if you went through this and added it up, they worked 51 hours this week. That means they had weekly hours, 11 hours of weekly overtime. Now, remember, we're paying whichever's more. We pay either the daily or the weekly. So which benefits the employee the most? That's the 11 hours of weekly. You do not add these two together. We are not paying 18 hours. That's that pyramiding rule. So first you look at how many daily, how many weekly, you pay whichever's greater. Then after that, you say what rate? Well, 2 of the hours on Thursday were in excess of 12. That puts those 2 hours in the double time zone. We don't have anything else in the double time zone. So with those 11 hours, we're going to pay 9 of them at time and a half and 2 of them at double time. So again, you can take your time and look at these slides and this example, and hopefully that will help you keep this straight. Now, I'm going to kind of mention a few things. Paid vacation. You're not required by law to offer paid vacation, but if you do, there's a lot of rules that come into play. With vacation, I strongly urge you to do the accrual method because vacation is considered as wages in California. So if somebody has vacation in the bank when they leave, you have to cash it out to them. And if they're earning it as they go, starting their first day of employment, then let's say, for example, 10 work days of vacation a year, 2 weeks. If they're accruing it, then by the time they hit 6 months, they will have earned 5 days of vacation. And if they quit, then you have to, if they've not used any, you're cashing out 5 days. At the front load method, if you're saying, hey, on the first day you're here, your start date, we're popping 10 days of vacation into your bank, and they either use it all really early and quit, or they quit, a week later, you're going to have to cash all that out because you put it in their bank. You can have reasonable caps. This is different from use it or lose it. It's saying, let's say 10 days a year is what you give people. And you say, once you hit 15 days, we stop accruing more. You don't lose anything that you already have in the bank. We just won't keep adding to the bank. Now, there are a number of issues that come into play to understand and decide each of the things noted in this slide. We don't have time to get into them, but I want you to see the issues. PTO is combined paid time off with vacation. We call it paid time off, which is sick and vacation together. So a lot of pros and cons on that. Definitely something you want to think about before you just do it. Sick pay. Now there's laws on sick pay. California requires you to give paid sick leave. And in this case, again, you have the accrual versus front load. And believe it or not, this one's better with the front load. the accrual can get complicated because of state rules on how you do it. So let me just kind of leave it at that. It can get a little crazy. The only time I think it's worth considering the accrual is if you have a lot of people who work such small part-time hours that they don't even hit 700 hours for the year. Then it's something worth considering. But you have to do it that way for everybody. So unless it's just about everybody in your workplace, I strongly recommend the front load. You might want to do it every calendar year. And the minimum in California is 3 days or 24 hours. So you can just put that in there. You can do more. COVID issued, during COVID, there were some additional supplements that were in play. I'm pretty sure those have all gone away, but you're going to want to double check. So you also, again, have local rules. California has counties and cities. Los Angeles, it's crazy. If you have an employee who even spends 2 hours in a week, any single week, if they spend 2 hours or more in Los Angeles County, other than literally just driving through, if they stop to drop something off, they're covered by Los Angeles sick pay rules. So you really have to know what's going on. Payment calculation, you pay on the regular rate, and you do not need to pay it out at separation or every year. That would be a bonus if you choose to do it. Some folks like doing that because it encourages people not to use the sick pay unless they need it. So a number of issues there to consider. Really quickly, rest breaks are required by law in California. The rules are here. And really you need to understand the time block, which is 1 rest break for every 4 hours worked or major portion thereof. So 3 hours is the major portion of a 4-hour period. And so that could be a time block. And so really what we look at is anybody who has a 6 to 8 hour shift is going to require 2 rest breaks. Below 6, let's say 3 to 6 hours, you're looking at needing 1 rest break. They should be not less than 10 minutes. I suggest not doing 15 because it starts bleeding into longer periods of time as people don't necessarily come back on time. They might want to combine it with their lunch break. You don't want to do that. So very important to kind of look at these guidelines here. You're going to want to have a written policy about this. Meal breaks, a similar thing. Employees who work more than 5 hours in a workday must get a meal break of not less than 30 minutes. It has to be really duty free. As I mentioned before, the rest breaks are on the clock, but this is clock out, start your lunch, and they need to clock back in when they return to duty. You don't have the lunch meetings that puts them on duty or on standby, like you have to eat at your desk. Same thing with breaks, actually, where they have to sit at their desk in case something happens. They really have to be relieved of duty, but with lunch break, because it's off the clock, they have to be allowed to leave the premises. Now, break ideally should be midway through, but no later than the end of the 5th hour of work. They better start it. Now, keep in mind, here's this example in here of when that end of the 5th hour is. A lot of people get confused. So we've got that written out for you to help, but you may as well try to schedule lunch breaks sooner than that. Don't just let it get pushed up against the edge where if somebody's just even stopped on the way to clocking out, now all of a sudden we have a meal break violation, because these can be very expensive. Now, again, you may hear, oh, somebody can waive their meal period if they're not working more than 6 hours. There has to be a written waiver. You may want to do it as part of your intake paperwork, but it's not permission for somebody to say, oh, I'm going to change my schedule. If I'm scheduling somebody to be in my shop for 6 hours because I have to have someone staffing the place for 6 hours and they have a meal waiver on file, then they should be there the whole 6 hours. And if they don't have a meal waiver, then I better not schedule them for 6 hours. And it's also not permission for them to change their schedule. Like, I'm supposed to work 6 hours, but you know what? 6 hours with a meal break, I'm going to just skip my meal break and work 5.5 hours and leave early. If I need you to be there from 9 to 3, even with a meal break where I know to cover you, you can't just say, hey, I'm just going to take my meal break, quote unquote, at the end and just skip it. and leave early. So keep that in mind. But even if they sign that waiver, the waiver saying if I'm going to be out the door in the parking lot, leaving for good that day, no later than the end of my 6-hour work, I can skip my meal break if I have that waiver on file. But if I work 6 hours and 1 minute, I now missed my meal period that should have started more than an hour ago. So again, this is a problem if you're scheduling people for something like a 6-hour shift, because this can easily happen. Maybe they clocked in 2 minutes early. You got to keep track of this. So this is an example where you may want to be careful with your scheduling. So again, you're going to want to have a handbook policy. The standard is that it's got to be, you're making these breaks available, meaning you don't have to force the person to take the break. No standby duty or lunch meetings. Don't forget, there may be a need for a third rest break or a second meal break. The hours are mentioned earlier. The reasons for missing the break matter. You need to have people report missed breaks because, especially with the rest break, it's on the clock. If you don't know that they missed it, you're going to find yourself with penalties, and people can just say they missed it, even if you know they got breaks. Timesheet information, certainly meal breaks are going to be on someone's timesheet, so you can see if they're doing it, but supervisors should be paying attention. Are they seeing people never taking rest breaks or meal breaks? Let's check on that. Let's find out what's going on and try to make sure they're taking their breaks. And also on the timesheets, you have language carefully worded to have people sign on their timesheets, not only that they are not lying about the time they entered, but that they got all their breaks or they were available, and any breaks they missed, they either chose to miss or reported as missed, or both. And again, there's detailed language in there. And then deducting automatically for a meal period, let's just assume everybody takes their half hour and just dock everybody for a half hour. Don't do it. They need to clock out for lunch, clock back in when they return, not only to avoid mistakes, but also lawsuits. Now, meal and rest periods, there's penalties if these periods are missed, these breaks if they're missed, or even if they're taken late. And the limit on this is 1 penalty paid to each employee who misses one. So this is not like to the group. If a specific employee misses their break or it's late, then on any given day, if they miss 1 or more rest periods, they get 1 penalty. And if they have the same thing, miss any number of meal breaks, same thing, 1 penalty. So the potential is 1 penalty for any number of missed meal breaks, 1 penalty for any number of missed rest breaks. So if you get that employee says, I never got any breaks at all, I never got any rest breaks, any lunch breaks, they're going to be able to claim 2 penalties, 1 for the meals, 1 for the rest. But even if they miss 2 rest breaks, it's still just the 1 rest break penalty per day. And there's a case recently that says that you pay these penalties at their regular rate. The penalty is equal to 1 hour worth of pay at the regular rate. And that's just a measurement. It's not counted like extra time worked. It's simply, this is the little package of money we're giving the person. How are we measuring it? We're measuring it by 1 hour worth of regular rate pay, which includes all those other bonuses and so forth that might be there. Paydays are important. We've only got a few more minutes. I'm going to really go through here. There's a lot of issues here. Again, your payroll work week, you don't have to have a payday for each payroll, 1 week every payday every week. But I think it's nice to have the 2-week pay period, because your payroll work weeks, you know what your overtime is going to look like when you close that pay period. If your pay period ends on like the 15th of the month, that could be the middle of your payroll work week. And that means you're going to be paying and then having to go back later to see if they did work any other overtime in that week, like on the 16th, 17th, or 18th, whatever that is, and figure out if you have to go back and adjust overtime, because maybe they only had daily overtime as of the 15th, but then by the 17th, 18th, whatever, turns out they had more weekly overtime than daily. Who wants to go back and refigure all that? If you have the 2 pay period, your 2 week pay period, 2 payroll work weeks, it's pretty easy. You're paying them every other week. People tend to like that. So more information here also about the pay stub, which let's talk briefly about that. By law, there are 10 items that have to be on the pay stub. You see them here. So I'm not going to just read those to you, but it's very, very important to know what they are. The inclusive dates of the pay period, you can't just say the 2 weeks ending such and such. The 2 weeks ending May 20th of 2023, you have to say, for example, the pay period, May 7, 2023 through May 20th, 2023, if that's your pay period. So again, all of these things need to be on your pay stub. You need to make sure your payroll person knows what they're doing, because if there's any flaw in here, we often see it with failing to put on the available sick time or mentioning how many missed break penalties were paid and at what rate. And employees are entitled to copies of their pay stubs, and plaintiff lawyers love it. We get lots of litigation where somebody goes to the plaintiff's lawyer, and the plaintiff's lawyer might look and go, yeah, I think you're telling me you think you were treated unfairly, but hey, I would have fired you myself. But let's look at those pay stubs, because I bet you anything we'll find some good stuff to sue them for in those pay stubs. And it might, beyond the pay stub violations, show that you weren't paid for missed meal periods or any other number of things, and that stuff can add up really fast. Scheduling issues, let's just mention this also quickly. First, you want to make sure your payroll work week and workday definitions are clearly defined. You're going to want to pick a start and stop time where you have the fewest people there. So for example, if you are a bar and you're open from noon until 2 a.m., you may just want to, and let's say you're closed on Mondays, you just might want to pick a work day, for example, that starts at 6 a.m., goes to 5:59 a.m., because guess what? You're not going to have people, when you shut down at 2, maybe they work a couple extra hours, but by 5 a.m., by 6 a.m., nobody's there. And nobody's going to start that early. So you're not going to accidentally have people having their shift cross the line from one payroll workday to another. So if you have that bar that closes at 2 o'clock, but your payroll workday is midnight to 11:59 p.m., whoever's working that final shift, they're going to have part of their work, their shift on one payroll workday and part of their shift on the other. So you want to try to do it when that's not going to happen. Same thing if you're closed on Mondays. Let's say maybe you're a restaurant, you're closed on Mondays. You may want to do midnight, 12 a.m. Tuesday through 11:59 a.m. Monday. So that again, it also means you're less likely to have anybody accidentally working on a 7th day as well. So you look at those issues and when you're deciding which to do. And if you have a graveyard shift, even if everybody else is scheduled for payroll work day, payroll work week, that's midnight to 11:59 a.m., you can still have that graveyard shift be a different time, such as noon to 11:59 a.m., depending on what works for you. So those are things to think about when you're scheduling people, when you're picking your payroll work week. You also want to make sure that when you're picking your pay day, you leave enough time between the end of your pay period and the pay day to fully process everything. Because I've seen people really go, oh, payday's on the 15th and the last day of the month. And that payday covers the 1st through the 15th. Well, how are you supposed to cut a paycheck on the 15th and put it in the employee's hot little hand if they're still working on the same day that's got to be in that paycheck? You don't know if they're going to call in sick that day, leave early, work overtime. Your pay period has to close completely before you can sit down and know how much overtime was in that pay period, how much sick time, how many missed breaks. Give yourself a little time. Now, you can't give yourself too much time. You can't say, I'm going to pay you, next month. For non-exempt employees, which we assume everyone is, because you're not exempt from the law, we're looking at, if you're paying every other week, when that pay period closes, you have to pay that no later than 7 days after the close of that pay period. If you're paying twice a month, let's say your periods are the 1st through the 15th and the 15th through the end, then you have a maximum of 10 days. You also cannot pay people monthly. You have to pay no less than twice a month. And again, when we do this, it's worth the extra 2 paychecks a year to process, to have those payroll work weeks really, really complete for your pay periods, so that it's easier to do the overtime calculations and so forth. So again, when you're scheduling people, make sure you have enough people that you can cover people's rest periods and meal periods on time. So that's, again, important. And again, consider different time, payroll work week or payroll work days, excuse me, for things like a graveyard shift. Quick comment on leaves of absence, because this is an important issue. We could do a half-day seminar on leaves of absence, but I want, again, have you be able to spot these issues. There are many, many laws that require you to provide people with time off, sometimes paid like sick leave, sometimes unpaid. And some of this applies even if you have only one employee. So sick leave is a good example. If you have even one employee, no matter how part-time they may be, they're going to have paid sick leave. And there's a number of other laws that require you to allow people time off. In fact, we used to do a seminar called Being There. When can I require someone to show up? There's that many different things. So basically, you're going to want to make sure you get all the policies you need, that you have to have for the size of your business. If you have anything over 5 employees, most everything in California is going to apply to you. But there again are going to be some local rules that you have to apply to your business and make sure you're following. But until you're able to get that all in place, which is really important, I urge you to get policies for the issues we've covered, which are the biggest ones that could lead to litigation. But on leaves of absence, if somebody asks for some time off, rather than say, no, I can't spare you, or even say, sure, unless you know for a fact it's not a problem, like they ask for vacation when it's no problem, then what you should say is, hey, let me check on that and I will get back to you as soon as I can. And then do not walk to your best advisor and find out what the entitlement is for this employee's absence. You do need to have some information. Why do you need it off? Because I need to know what you're entitled to. Let me check on it. So you get qualified advice, and then you give the employee a written response, text message, email. Those are written responses saying, hey, I checked. Yes, you can do this, but you're going to have to get me a doctor's note sometime in the next week, that sort of thing. And then stay on top of all of their absences. So don't wait until somebody's gone a month or two to say you're frustrated. What can I do? If somebody is out for an extended period, you are going to want to make sure that you've worked it all out with them from the get-go, and they know what they're entitled to. They know what communication you're going to require from them. And then stay on top of it. If you're going to need a doctor's note on a monthly basis, then make sure you get that from them. And if they want to extend a leave, you've approved it through a certain date, and they say they need more time, then you're going to want to know what your rights are. Do you need to extend it? Same thing. If you have even 5 employees, if you offer health insurance, you're going to need to continue that health insurance in effect and pay your share of the premiums. But if you don't do the proper paperwork, then there's a clock on that. You're only obligated to do that for up to 12 weeks in most situations. But if you don't do that paperwork, that 12-week clock doesn't even start to run until you've done that paperwork. So if you have anybody who needs a leave of absence, you want to make sure you know what applies, and you want to stay on top of it, do the paperwork, get advice right away so that you're not falling behind and lose control of that situation. So very important to understand those issues. Now, I know we have not left much time here, and this was really, really broad and really fast. We could do hours on just about almost any slide in here, but I'm hoping it helps you really spot issues. If you have questions, you can get in touch with me. I encourage you to make sure that you get signed up for all kinds of newsletters, take seminars, get more knowledgeable on these issues. But make sure you get advice from various professionals. Don't try to do it alone. No need to try to do things all by yourself. Women's Business Center, great resource. They'll help you. So you're not alone in this. There are folks who want to help you and can help you. Again, make sure you get California law and you're checking all the local rules that apply to you. And you should be okay.